me and my colleagues who defend people from these BitTorrent actions have seen the abusive process claim fail. You're going to see why it fails, and that's why I'm bringing it to you today. But this is not the end of defendant's defense. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So Strike3 Holdings is at it again. If you don't know, Strike3 Holdings is one of those copyright trolls. I put it in quotation marks because this is a matter of opinion. They have not been found to be a copyright troll anywhere but Judge Royce Lamberth's in the DC District Court, and they're appealing that. And so far, this is not the same thing as Prenda Law, and maybe it's the same thing or a similar thing as Richard Leibowitz, but so far, they just get sanctioned once in a while. They aren't an illegal copyright troll, is what I'm trying to get at. I'm not trying to defend them, though. However, they do win in this case. So prepare yourselves. Brace for Strike3 Holdings to win this matter that comes before the court on Plaintiff Strike3 Holdings' motion for partial summary judgment. That's important because if you read certain articles, which are very well written, and I enjoy them, their authors and everything, but if you read the somewhat clickbaity title, it makes it sound like Strike3 Holdings has won. They haven't. They've won partial summary judgment. And the title is correct. It's very technically correct. For partial summary judgment as to defendant John Doe's abuse of process counterclaim. Having reviewed all papers filed in support of and opposition to, the court enters the following order. This case is one of 9 actions filed within a 2-day period by plaintiff Strike3 Holdings, each alleging a subscriber associated with a internet protocol or IP address has infringed one or more of Strike3's copyrighted adult motion pictures. The other 8 matters were voluntarily dismissed by Strike3. In 5 cases, they reached a settlement. In a couple others, Strike3 elected not to pursue another matter, and in the other 2 actions, Strike3 was unable to effect service and unable to secure entry of default. Well, that's why we've got the dog cam there, to explain why there's so much noise. This lawsuit is the only one that remains pending, albeit not because of Strike3's infringement claim, which was voluntarily dismissed on August 24th, 2018, but as a result of defendants' counterclaims for a declaration of non-infringement and abuse of process. Strike3 now moves for partial summary judgment as to defendants' abuse of process claim. And then down here at the footnote, Strike3 has indicated that it would consent to a declaratory judgment of non-infringement provided that such a judgment does not entitle defendant to any attorney's fees or costs and reserves all of Strike3's rights to prosecute defendant's son. This issue is addressed in Section C. That's good because that was my first concern here. I'm being serious. The abusive process claim, we've seen this before, or at least me and my colleagues who defend people from these BitTorrent actions have seen the abusive process claim fail. You're going to see why it fails, and that's why I'm bringing it to you today. But this is not the end of defendant's defense. If Strike3 files against the wrong person, you can still file for a declaratory judgment of non-infringement. And this is also a bit of a controversial point because not every judge in every district recognizes the declaratory judgment of non-infringement. Sometimes what they say is, well, a declaratory judgment of non-infringement is the exact same thing as the court agreeing that defendant is not liable to the plaintiff. So why don't we just adjudicate plaintiff's claims of copyright infringement and get rid of those claims if that's appropriate, rather than both a copyright infringement claim from plaintiff and a counterclaim of a declaratory judgment for non-infringement from defendant. I got that right. In Washington, the elements of the tort known as abuse of process are as follows. 1. The existence of an ulterior purpose to accomplish an object not within the proper scope of the process. 2, an act in the use of legal process not proper in the regular prosecution of the proceedings. And 3, harm proximately caused by the abuse of process. Remember what proximate cause is. That is a legal connection, not just a but-for connection, but a legal connection to the alleged harm or wrongdoing. So the court has to recognize that the things are connected enough to require or allow a legal remedy. The crucial inquiry is whether the judicial system's process, after having been made available to secure the presence of the opposing party, has been misused to achieve another inappropriate end. The mere institution of a legal proceeding, even with a malicious motive, does not constitute an abuse of process. Even the filing of a baseless or vexatious lawsuit is not misusing the process, and no liability attaches if nothing is done with litigation other than carrying it to its regular conclusion. To prove his abuse of process counterclaim, defendant must establish that Strike3 engaged in an act after using legal process to accomplish an end not within the purview of the suit. The acts about which defendant complains fall into two categories. 1, alleged misrepresentations made to obtain summons, and 2, allegedly improper discovery efforts. The first set of accusations do not an abuse of process claim make. Defendant contends that Strike3 knew but failed to disclose to the court that it had no way of linking the subscriber of the IP address at issue with the allegedly infringing behavior. Even if true, such assertion does not establish an abuse of process because it involves events that occurred before, not after, the use of process. Moreover, given the unsettled nature of the law preceding Strike3 Holdings' voluntary dismissal of its copyright infringement claim, defendant cannot show that Strike3 engaged in behavior not proper in the regular prosecution of the proceedings. The alleged misrepresentations upon which defendant's abuse of process counterclaim is premised all occurred before the Ninth Circuit issued its landmark decision in Cloar, Nevada versus Gonzalez in 2018. There, the appellate court for the first time made clear that a copyright infringement claim based merely on a defendant's status as a subscriber of an IP address associated with infringing activity does not cross the threshold of plausibility that pleadings in federal court must satisfy. And yes, I pointed this out to the Eastern District of Virginia and the Eastern District of Pennsylvania, and they did not agree. So we now have a district court disagreeing with the Ninth Circuit, and it's going to be a fun one to resolve in the coming years. Who knows? Maybe my name will be on one of these cases someday. Strike3 Holdings' conduct in this litigation cannot be judged by standards announced after it voluntarily dismissed its infringement claim. So the Cloar, Nevada case came after this case, so this case can't be judged by that standard. Defendant's second group of grievances relate to Strike3's defense against the abuse of process counterclaim rather than the prosecution of its now defunct copyright infringement claim, and likewise cannot form the basis of an abuse of process claim. Defendant contends that Strike3 has targeted his son and misused the discovery process to explore whether defendant's son, other family members, or friends engaged in infringement of Strike3's copyrighted materials. For support, defendant cites his depositions long after Strike3 voluntarily dismissed its copyright infringement claim, but while Strike3 faced potential liability on defendant's abuse of process counterclaim. Strike3 was entitled to pursue a theory of defense that another member of the defendant's household or someone with access to defendant's IP address had infringed one or more of Strike3's motion pictures via the BitTorrent network, which would undermine defendant's allegation that Strike3's copyright infringement claim was frivolous and asserted for purely extortionist and other improper purposes. Defendant simply has not offered the requisite affirmative evidence of anything done by Strike3 in connection with this action other than carrying it to its regular conclusion. So what they're saying there is that in order for it to be an abuse of process, Strike3 would have had to do something more than use the process to conduct a basic investigation. Even though it's fairly egregious to get accused of copyright infringement and then have a plaintiff be able to ask questions under oath or whatever, that is the normal process. If I think someone's committed copyright infringement, if you think I've committed copyright infringement, you can make the accusation, and if you're wrong, then the remedy is I get to counterclaim for my fees and costs, which is what the plaintiff and the defendant are doing here. The defendant is now counterclaiming for something, anything that will allow them to get fees and costs, and that's the declaratory judgment of non-infringement. So let's see what the judge says about that. As acknowledged by Strike3, defendant is entitled to a declaratory judgment that he has not himself infringed any of Strike3's copyrighted works. Defendant, however, has not sought summary judgment, and the court is not inclined to grant such relief on its own in light of the related issue of attorney's fees and costs. Counsel are directed to meet and confer, if possible, to file a form of proposed judgment within 21 days of the date of this order. With respect to attorney's fees and costs, the parties shall attempt to reach an agreement concerning whether and, if so, how much defendant should receive, bearing in mind that under Copyright Act, attorney's fees are discretionary and the court may decline to award them. If the parties cannot resolve the issue of attorney's fees and costs, defendant shall file an appropriate motion within 21 days of the date of this order. And we'll check the docket to see if that's there, and we'll report on that for you. So the court orders that Strike3's motion for partial summary judgment is granted and the defendant's counterclaim for abuse of process is dismissed. The counterclaim for a declaration of non-infringement remains pending, and the court set the dates as we discussed above. The court grants the motion to seal some responses unrelated to, I'm sure it's just trying to keep everything private while they're litigating, which is something we do for defendants. And counsel shall meet and confer as discussed above. And this is Thomas Zilli, United States District Judge for, I think it's the Western District of Washington. So that's how things are done over on the other side of the country. It's a little bit different than they're done on the east side of the country, huh? Look out for those double standards. So yeah, basically don't download adult entertainment without paying for it. At least don't do it via BitTorrent without a VPN going, and no, that's not legal advice, and no, I can't guarantee that that would prevent you from incurring liability, and I certainly don't want anyone to be downloading illegal material. But if you're downloading material and you're using a VPN, I have not yet seen anyone get caught for while using a VPN. Is all I can say about that. I'm not encouraging anyone to commit piracy. By all means, these producers are producing material that arguably is worth paying for. If it's worth downloading illegally, it's much better to just pay for it then. So let me know what you think about that. So thank you for joining us. That is our show. I am Leonard French, your favorite copyright attorney. Thank you to our patreon.com/ljfrench and sponsors.org/law supporters. Your financial support makes this entire thing possible. We do a lot of work for you here, but I want to let you go. So thank you very much to our $500 supporter for the month of July, Joshua Davis from TandaPay. We'll be making a video about his social insurance program that uses blockchain technology. Thank you to our $50 plus supporters, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Snorre Wisotzky. And thank you to the $5 plus supporters who are on the LED panel behind me and in the description of the videos below. I'll leave some room here for dog video. Love you all. I'm Leonard French, your favorite copyright attorney. Have a great week. Thank you to Brandon and Technical in the virtual studio today, and I'll see you guys later.